And call Jeremiah White, 2022 CF 2079B. Mr. Bernstein on behalf of the defense, Mr. Nagel on behalf of the state. Jeremiah White.
Good morning, Your Honor.
Good morning, Mr. Nagel.
The state anticipates that this will be a change of plea, Your Honor. The approach with the paperwork.
We've got everything transferred into this court, so it's all going to be done right now.
Give me just a moment. All right. Good morning, Mr. Bernstein. Good morning, Mr. White.
Good morning, Your Honor. Our intention is to enter a negotiated plea this morning, Your Honor. It's very similar to what you've heard the last time we were in court. He would be withdrawing his previously entered pleas of not guilty. And in case 2022 CF 2079, he would be pleading to count 1, attempted second-degree murder, and that's with discharge, so there would be a mandatory minimum 20-year sentence on that. That's a second-degree felony. Count 2, shooting into an occupied vehicle. That's also a second-degree felony. And then in case 2023 CF 3804, which I do not represent him in, but regional counsel does.
Right.
And that case has been transferred to your division per Judge Greaves' order. And there would be a plea in that case to count 1, attempted second-degree murder, which is a second-degree felony. And count 2, possession of a firearm by a convicted felon, which is a second-degree felony. The negotiation is very similar to exactly what this court indicated at our last hearing that you would be willing to accept. The defendant shall plead nolo contendere in 2022 CF 2079B to count 1, attempted second-degree murder with discharge, and count 2, shooting into an occupied vehicle, a second-degree felony. State will dismiss the remaining counts, and the parties agree to a sentence of 20 years DOC, minimum mandatory. In the other case, 3804, 2023 3804, he would be entering pleas to those charges that I've already announced, and the state agrees to a sentence of 20 years in the Department of Corrections, and these sentences would be run concurrently. And the plea form has been prepared with both case numbers, and I've gone through it with my client, and he has initialed the paragraphs and signed the plea agreement page, so we're ready to qualify that plea if the court is ready to proceed.
All right, and that was, I want to clarify for the record, that was based on some evidentiary issues the state placed on the record. Is that correct? That was
Yes.
discussed at the last court hearing.
Yes, Your Honor. I believe Mr. Margulies announced some of the evidentiary issues, but it will be the same thing that I would announce to the court today, just in terms of being able to, the firearms that were collected not being the firearms used in the crime, placing occupants in the vehicle, some of the evidences that the state announced to the court that we have not received back from RJ Lee Group, so various issues that the state believes this would be a good plea for both the state and the defendant.
And in terms of any listed victims, if there was a discharge, was it connected to any listed victim?
It is, Your Honor. So 23 CF 3804 is listed to a victim, neither of which have been really forthcoming or cooperative in prosecution. I have asked my witness advocate to reach out to both of those one last time to attempt another contact to alert them of the plea. I've not heard back yet.
Okay, fair enough. All right, Mr. White, raise your right hand to be sworn, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Mr. Bernstein, you may proceed.
Thank you, Your Honor. Mr. White, you and I have gone through this petition to enter a plea of nolo contendery at the jail a couple of times, and most recently this weekend. Is that correct?
Correct.
And now, as we went through this, as I read these paragraphs to you, I asked that you place your initials by these paragraphs. Are these your initials?
Yes, sir.
All right. And on page 4 of 6, just a minute here. There is, where I wrote out the plea agreement, there's a signature blank where it says defendant. Is that your signature?
Yes, sir.
The time we went over this document, did I answer all of your questions about the information that was contained in it?
Yes.
All right. And do you feel like you understand what's stated in this document?
Yes.
Okay. And we've discussed the evidence in this case. We've discussed the depositions that we've taken or tried to take. We've talked about the discovery in this case, and I've given you a copy of the complete report of the discovery, and you've had a chance to read over that. Is that fair?
Yes.
All right. Do you feel like this is the best way for you to resolve these two cases?
Yes.
All right. I want to go over some of the rights that you're giving up, and they're put out on the second page. Particularly, you have the right to have a trial in each of these cases, the two cases. At that trial, you have a right to have a trial by a jury. At that trial, you have the right to be represented by an attorney, and if you couldn't afford one, one would be appointed to represent you. And I've been appointed to represent you in the 2079 case, the 2022 case, and the regional counsel has been appointed to represent you in the 2023 case, correct?
Correct.
Have you had enough time to talk to me about what the specific events and issues are in the 2022 case that you and I have been talking about for months?
Yes.
Do you feel like you've had enough time to talk to your attorney and regional counsel about the 2023 case and the issues in that case?
Yes.
All right. And you've been shared the discovery in each of those cases, is that correct?
Yes.
All right. Do you feel like this is the best way to resolve these cases?
Yes.
All right. You understand that in each of these cases, there was a sworn complaint filed back when you had a first appearance. And there were facts that were set out in each of the cases in a sworn document signed by the investigating officer. You understand that there was a probable cause finding made at that time, that there is probable cause for the facts of these cases and the allegations. That the court, we're agreeing that the court can review the factual basis that's stated in those sworn complaints. In fact, we're willing to stipulate that there's a factual predicate for this plea in each of these cases. Is that correct?
Yes.
All right. Are you satisfied with the advice and counsel I've given you in the 2079 case?
Yes.
Are you satisfied with the advice and help that the regional counsel has given you in the 2023 3804 case?
Yes.
All right. Do you feel like this is what you need to do and it's in your best interest?
Yes.
All right. I've also discussed with you the fact that if you were not a citizen of the United States, you could be deported for the type of charges that are in both of these cases. That since you are a citizen of the United States, we don't think that applies to you, but we've discussed it, correct?
Yes.
All right. We've also talked about the Jimmy Rice warning, and that is that you don't have a history for that type of offense, and there's no allegation of anything that would go along in that theme in either of these charges. But we've warned you that if at the time of your release there was some concern that the authorities could put in a petition and have a hearing, you could be committed civilly for treatment if that were the situation.
Yes.
All right, so while we don't think it applies to you, we've discussed that. All right. And I've checked, and you have 1,436 days credit for time served. Is that right?
Yes.
All right. Are you satisfied with the advice and help I've given you as your lawyer?
Yes.
And that's in the 2022 case. In the 2023 case, are you satisfied that regional counsel has, with the advice and help that they've given you as your lawyer?
Yes.
All right. So is this the way you want to resolve both of these cases? Your Honor, I'm going to present to the court the executed plea agreement form, and I will state on the record that I do believe that this is a willing and voluntary waiver of his rights to go to trial, and this I'm submitting as a voluntary plea. And then also, I'm sure the court has the official order, but the second case, the 2023 case, has been transferred to your division, so you can dispose of both of these cases this morning.
Correct. All right. Thank you, Mr. Bernstein. Mr. White, I have all of your plea paperwork here in front of me. I also have your sentencing score sheet. By putting your initials, by signing this form, you're indicating to me that you understand the rights that you have and the rights that you're waiving by entering a plea in not only this case, but the other case that was in front of Judge Greig. Do you understand?
Yes.
Anyone pressure you, force you, or coerce you into entering a plea in both cases?
No, ma'am.
Are you under the influence of anything that may affect your ability to understand what you're doing?
No, ma'am.
You're not a U.S. citizen, you could be deported, you understand that?
Yes, ma'am.
And Mr. Bernstein, whenever the Jimmy Rice warning, I don't see any offenses that would qualify, but if there are any in your record, you understand that you could be civilly committed upon your release from the Department of Corrections.
Yes, ma'am.
Understand? Are you satisfied with the advice and counsel of Mr. Bernstein?
Yes, ma'am.
Do you have any questions for Mr. Bernstein or for me?
No.
I'm going to find that the plea is freely, knowingly, and voluntarily entered with an adequate factual basis. I did review both case files prior to court this morning upon notification that there was a request to transfer the other case into this division. And based on the, again, the evidentiary concerns placed on the record at the previous court hearing, and with the at least consideration of the listed victims, I am going to follow the agreement set forth on page 4 of 6 of the plea form. You'll be adjudicated guilty of the counts listed in the plea agreement under 22 CF 2079, attempted second-degree murder, and count 2. I think you're writing
Shooting into an
to read the
occupied
line, Mr. Bernstein.
It's shooting into an occupied
Shooting into an
vehicle.
occupied vehicle. which is also
Correction. I'm sorry, Your Honor,
Correct?
correction. It's 790.5, shooting from an occupied vehicle.
Shooting from an occupied vehicle, which is also a second-degree felony. And then also, that's in 2079, correct?
Yes, Your
22
Honor.
CF, and then in 2023 CF 3804, I'm going to adjudicate you guilty of attempted second-degree murder, and in count 1 and count 2, possession of firearm by a convicted felon.
Your Honor, the only thing I would add is that in 2079, the attempted second-degree murder is with discharge, which triggers the 1020 life
Right.
provision.
Correct, Your Honor. So in both cases, 22 CF
They should both
2079.
be with discharge, correct, to run
They-
concurrent?
Yes, Your Honor, they're both discharged, so both of them supersede the 15-year statutory maximum as currently charged for counts 1. So for count 2 in both cases, it would only be 15 years DOC because they would not qualify under 1020 life.
Correct.
Um,
But count 1, it's discharged, so it is the 20, correct?
Correct, Your Honor. And the benefit that Mr. White is receiving is, of course, if he were to proceed to trial, the state was going to amend the charging document to count 1 being attempted first-degree murder with the discharge of a firearm, making it a potential life felony.
Correct.
And then for 23 CF 3804, that is count 2, not that it matters, it'll be absorbed into it, but it's a 3-year mandatory minimum for actual possession of a firearm by a convicted felon.
Absorbed into the 20 years, correct?
Correct, Your Honor, because it would still be beholden to the 15-year max.
I am going to order all applicable fines and cost of prosecution. There's no probationary period, so are you requesting a civil judgment or a payment plan on behalf of your client, Mr. Bernstein?
Do you want a payment plan at the end to try to get a license, or do you want to just have it as a civil lien? You'd like to do the payment plan at the end.
All right, I'm going to order a payment plan credit. Credit, is it the days?
It's 1,436, and just as sort of a housekeeping matter, Your Honor, that's in 22 CF 2079. In 23 CF 3804, Mr. White would only show 500 and something days, but the state is waiving that and giving him the same credit for both. He's been continuously in custody. That's just by virtue of when the state charged the charging document, but the state is allowing him to have the same credit on both cases, if the court will allow that as well, Your Honor.
So it's 20 years in count 1, 15 in count 2, both count 1's minimum mandatory for 20 years, and then count 2 on 3804 is the minimum mandatory 3 years.
Yes, Your Honor.
That's what I have on my notes. Is that what you have?
That's
Mr.
correct.
Bernstein? All right. Anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right. Good luck to you, Mr. White.
There's no-